Anna, you are on mute.
Thank you. Apologies. Good morning, everyone, and thank you for joining us today. Before we start, may I please ask you to make sure you're on mute and that your camera is off. That makes it much easier for the event, for the webinar to run. As you may have noticed, the event is recorded and will be made available on our website afterwards, and we will be sending out the link to the recording to all of you, together with an evaluation form. My name is Anna Drozd, and I'm the interim head of office of the UK Law Societies, and in here we represent 3 UK law societies from England and Wales, Scotland and Northern Ireland. And we have been in Brussels for more than 30 years, and we can continue to represent the profession and monitor key EU policy and law developments that are relevant to them. Today we are going to focus on the Commission proposal for EU regulation on foreign subsidies, which was published on 5th of May this year. The proposal is designed to address the distortive effect of foreign subsidies in the single market, and it follows the adoption of the white paper in June 2020 and an extensive consultation process with stakeholders. It is also part of a wider package called New Industrial Strategy. And of course, as with any new instrument, the proposal raises numerous questions about this impact and practical implication, how it's going to work, and how it sits in the wider regulatory context. There are questions about the impact of the new regulation and how it will work together with other regimes, for example, the EU state aid rules and procedures, EU merger regulation, or FDI filing obligations. We also thought that it would be good to look at how the proposal sits in the overall context, and what kind of overall regulatory direction of the EU we can talk about, and how the international trading partners of the EU and other countries will react to the proposal, and what kind of reactions we could observe so far. And of course, an important subset of these considerations is the impact of the new proposal on the relationship with the UK and the provisions and subsidies in the trade and cooperation agreement that was concluded, well, recently ratified. And to address those questions, we have invited a great panel of experts. And with us today, we have Alexandre Bertuzzi, who is a case handler officer in the European Commission, and he currently specializes in mergers. And he also worked as a case handler officer at the Commission specializing in antitrust and mergers. Welcome, Alexandre. We also have Alec Burnside, who is partner at Dechert and who practices in the field of EU and UK competition law, working on cartels, dominance, mergers and state aid, as well as the control of foreign direct investment and EU law more generally. Alec is admitted to practice in the UK and Belgium, and it currently is a member of EU Committee of the Law Society of England and Wales. Welcome, Alec. And last but not least, we have Siobhan Kahmann, who is of counsel in CMS-CMNO in Brussels and has practiced EU and UK competition law for over 10 years in Brussels and in the UK, in addition to counseling clients on state aid subsidy and a wide range of regulatory and trade matters. Siobhan is the Law Society of Scotland's elected International Council member and is an active member of its Competition Committee, Tech Committee and Trade Working Groups. In addition, she's also observer member of the EU Committee of the Law Society of England and Wales, representing the Law Society of Scotland. So welcome, Siobhan. On the programme, we also had a fourth panelist, Merit Ortrop from Freshfields, but unfortunately she couldn't join us today. We thought that we would start with a short presentation to set the scene and to present the key elements of the proposal. And from Alexandre. Alexandre, the virtual floor is yours.
Many thanks, Anna, and thanks for the welcome. Let me try to put the file on screen, share it with everyone. Should take me not too long. And maybe while the document loads, let me just a short disclaimer. Of course, I will be presenting the the Commission's proposal, but of course I will be speaking in my personal capacity, and nothing that I say is of course reflective of an official Commission position. This being said, I think if indeed the document shows for everyone, I can get started. Okay, very good. Well, good morning, everyone. I'll try to present the proposal briefly, highlighting the main features, and I think there'll be then plenty of time if there are questions on specific points. So the general objective, I think, is quite clear of the proposal, is to ensure a level playing field. Why? Because while we have EU state aid control within the internal market, meaning control of aid given by member states, we do not have the same for foreign subsidies. And we have in our gap analysis, in our impact assessment, we have determined that current tools, be they trade tools or competition tools, do not allow to adequately tackle the issue of foreign subsidies distorting the internal market. And so we have made a proposal, which is now with Council and Parliament. And the main features are the following. We of course define what we mean by foreign subsidy. I will detail all of these points in the following slides. And then we set up several tools, 3 different procedures: a general Exoficio tool, very similar to the antitrust logic, and then 2 specific ex ante notification tools following more the logic of ex ante merger control. We of course set out a legal standard and elements to assess the distortion in the internal market. And then we have a specific feature, a balancing test, meaning that we balance the positive and the negative. And to the extent that still that we find that there is a distortion of the internal market, we then suggest possible regressive measures to remedy the distortions. In more detail, starting with the more general points. So the legal bases are there, as you see. I don't propose to spend too much time on these unless there are specific questions. Maybe focusing also on the main differences with what we had set out in the white paper, and also taking into account the feedback we received in the public consultations. In the proposal, the Commission is set out as the sole enforcer, which is a difference with the white paper, where we proposed also to associate member states as enforcers. And as is written there, this is largely in view of the feedback and really with an objective of efficiency, of limiting the burden on companies and administrations alike, and also to have a uniform application of the rules, considering that this would be a new instrument, a new legal instrument with no enforcement experience. We also propose to combine, as I mentioned, ex officio and ex ante notification tools, again, with a view of having an effective but proportionate tool. So definition of foreign subsidy, it is a financial contribution granted by a third country, which confers a benefit to an undertaking and is selected. On the right-hand side, you have a few examples. In essence, this definition draws very largely from existing definitions. It is very close to the state aid definition, also close to the definition of subsidies under the WTO. So a technical definition, but not one which, at least in our view, is necessarily very surprising or original. If we move to the distortion of the internal market, so the heart really of the instrument, this instrument is really to tackle foreign subsidies to the extent they distort competition in the internal market. When do they do so? So first of all, when they improve the competitive position of the undertaking concerned in the internal market, and in so doing actually or potentially negatively affects competition on the internal market. How do we assess this? Well, what we propose is 2 different ways. First, we set out indicators, which are in our view, based on our experience and also the feedback again received in the public consultation, are those features which would be most relevant to assess whether there is a distortion in the internal market. So the amount, nature, and purpose of the subsidy, the situation of the undertaking and of the markets concerned, and the level of activity of the undertaking in the internal market. Building on these indicators and also on the state aid experience, state aid being our main benchmark for this instrument, of course, with the objective of leveling the playing field, we also set out a number of categories of subsidies which we consider most likely to be distortive. So you see them listed there: subsidies to ailing undertakings, unlimited guarantees, direct facilitation of a concentration, and subsidies facilitating the submission of an unduly advantageous bid. As I just mentioned, this is on the basis of the experience that these subsidies in the EU, so state aid, in these categories are, in the overwhelming majority of cases, found to be distorted. And so likewise, we would apply the same framework for foreign subsidies. The balancing test. This is also a feature of our proposal, which has evolved a bit from the white paper. The idea is quite simple, is that, of course, foreign subsidies, like EU subsidies, may have also positive effects. And so we propose to balance the positive and the negative. Of course, we do this only where we find that there would be negative effects from foreign subsidies in the internal market. And you can have two main outcomes, of course. Either the positive fully outweighs the negative, and then the assessment stops there, or the positive only partly outweighs the negative, and then you need to combine this with regressive measures or commitments, which, as you can see here, well, we have let's say a bouquet of different measures which are inspired by our competition tools, in particular state aid, but also antitrust and merger control, and also in a way, well, yes, but also public procurement rules for the specificity of the public procurement module. I think these are not particularly original, so I won't spend too much time on those. Focusing maybe on the procedures, I mentioned we have three different tools. The Exoficio tool, as I mentioned, follows the antitrust logic, and so you investigate behavior ex post. To do so, you have a broad set of investigative powers, which again draw very largely from the competition instruments. So the ability to request information, to carry out inspections with procedural fines and penalty payments. Also a broader possibility, again, not linked to specific cases, but a possibility to have market investigations. And at the last bullet here, non-cooperation, this draws more from trade defense instruments. It's the ability when really there is no cooperation from the relevant undertakings to make decisions on the basis of the facts available. That is an encouragement for them to cooperate, meaning that if they don't, they will face the consequences. If we move to now the ex ante notification tools, we have one for concentrations and one for public procurement. In both cases, the idea is really to have very targeted tools, ex ante notification tools, to target the largest deals, with those which are most likely to distort the internal market, and to combine these then with the Exoficio tool to assess possibly any behavior. So following that logic, you see here that there are thresholds for this notification conditions. These thresholds are set out here. You can see them. I think an interesting point is that they are higher than what was initially considered or set out in the white paper. The reason for this is that we've largely taken into account the feedback received in the public consultation, with a view to really have a really targeted instrument, thereby limiting the burden on businesses and administrations while preserving the effectiveness of the tool. I mean, both for this specific tool, but also in combination then with the more general Exoficio tool. It's an ex ante notification, so of course you have a suspensive effect, and you have obviously time limits for the Commission to make decisions. Maybe a specificity for those familiar with merger control is that we have also the possibility to request ad hoc notifications of concentrations which would fall below the threshold. And if we do that, then of course the procedural rules of ex ante notification apply, so suspension, etc. The public procurement module is quite similar, again, an ex-ante notification. The threshold is, of course, adapted. It's a different situation, so it is about the value of the procurement contract. But again, you have ex-ante notification, suspension, and time limits. And maybe a final word, which I think we will be focusing on in this webinar, which is probably interesting, in particular for practitioners and businesses, is the interaction of this proposal with existing instruments. Here we list a few, and I think Alec will make this discussion more concrete in a second. But indeed, there are a number of existing instruments, and it will be very important to determine exactly how this new instrument fits in that whole environment. Many thanks.
Thank you very much, Alexandre, for this very quick overview. My apologies for not actually inviting you to already ask questions in the chat. I think this webinar is structured in more like a discussion. So I would encourage you to ask questions throughout the webinar in the chat, and if possible, we can also ask them in person. Before I go to other panelists, Alexandre, I'm wondering if I could ask you one question. I think you started already talking about this, and it's and indeed it touches upon the relationship of the proposed regulation with other regimes. You mentioned the definition of a foreign subsidy and financial contribution, and I'm wondering if you can elaborate a little bit more on the scope of the proposal and really how it sits with how it interacts with other instruments.
Of course, happy to do so. I took off the slide, so I don't propose that I put it back up, but I'm sure that also the participants might be able to get them thereafter. I think, as I said, I think the definition of foreign subsidy largely follows existing definitions, and in particular, one thing which maybe I did not flag already is that we were very attentive to ensure that our proposal would be fully compatible with international obligations, and in particular WTO rules. And so in that light, I think the definition is largely aligned with WTO definitions of subsidies. Although I have to say that you will excuse me for some of my ignorance, because I'm not an expert of that particular field and of state aid. Maybe an additional point thereon is that it is, as it is under WTO rules and under EU rules, quite a broad definition. In particular, financial contributions can take a variety of forms, and so it is not limited to a direct grant or a direct loan. There's really the aim is also to have a very broad net to capture, let's say, the full risk, and then of course when we consider the possibility of the distortion of the internal market, then of course we apply a robust assessment on the basis of evidence to have a reasonable implementation and outcome on a case-by-case basis. But I think the intent was indeed to have, let's say, a broad net to begin with, to be able to correctly assess all of these possibly problematic situations.
I have a question narrowly on that point, if I may. Alexandre, is there some extent to which this instrument could capture reserved monopolies on the home market, which give the foreign enterprise obviously a great advantage? And to put it in concrete example, we had the train merger recently where CRRC had the monopoly of sales in its market, so that the market had to be defined as the world excluding China, if I recall. Does that somehow come into your scope here?
Thank you, Alex. So yeah, let me try to say what I can say. I mean, in a way, you will have noted probably, I think you might be referring to that in the white paper, we had a specific mention of this aspect generally. It wasn't necessarily phrased exactly in this way, but sort of taking into account the situation on the domestic market, let's say, in our assessment. Based on the feedback we received, you will have noticed that the proposal does not contain this. And I think in the proposal, we really kept what we understood on the basis of our investigations, in particular taking into account the feedback we received, that really those features which we thought in the indicators, I mean, maybe let me be explicit, those features which we felt would be most relevant in the vast majority of situations to assess whether there is a distortion of the internal market by a foreign subsidy. And this does not feature there. This being said, the list is not an exhaustive list. So I think it cannot be excluded in principle that in some very particular case, this dimension might be relevant. But again, we're focusing on distortions of the internal market. And so I think that is the main reason why we feel that probably this is not the main thing which is liable to affect the internal market. And you will have noticed that our indicators are about what happens in the internal market. Well, of course, we think that would be probably the first order consideration. Again, we cannot exclude anything, but in our view, this is perhaps not the most directly relevant.
Yeah, thank you very much, Alexandre. Perhaps one more question from me. Or I can actually see a question in the chat already, but before I go to that, perhaps one question from me, and it's more about a wider context and the reception that you have received. Can you tell us a bit more about the reactions to the proposal?
Happy to do so. I think especially because we were happily surprised to see that the reception has been, at least in our view, relatively or even very positive across the board. Of course, here and there have been some questions, some entities highlighting possible difficulties, and in particular, this is a new instrument. Of course, it is not fully clear yet how exactly it will be applied in practice, and I think that to a certain extent that is only natural. Well, especially because it's not even adopted yet. But I think generally the reception has been very positive, probably because we've been quite attentive to take into account the feedback that we've received also from businesses and business associations, to try to minimize the administrative burden, to make it really a targeted and effective tool. And at the same time, also reception internationally, at least the informal first feedback that we've received is one of keen interest. We have not, at least not us directly, received sort of very critical views from third countries or entities from third countries. So in a sense, for the moment, we're quite happy in that regard.
Thank you. You picked up on the issue of administrative burden, and I think we're going to come back to this a bit later in our discussion on the practical implications for operators as the proposal currently reads. In the meantime, we have a question from Jan Blocks. Will the mix of state aid and ASCM language in the proposal not lead to confusion? For example, the notification thresholds are based on financial contribution, not on benefits subsidies. A building contractor doing construction works for foreign government will therefore likely meet the thresholds, even if these works are done at market prices.
I mean, so I'm not sure that the confusion. I mean, confusion. I don't know if there's a confusion here, and I don't know if it stems for a mixing of state aid or ASCM language. I think the question is more in a way. How broad and how clear this notion of the financial contribution is for a notification system. I think there may be challenges in practice. In particular, I think the question refers to public procurement, where I have to say I'm a bit less of an expert. What I would say, though, is that, of course, to have an ex-ante notification system, you need objective elements, and this enables clarity for businesses to know when or when not to notify cases. And so we considered, I think it's fair to say, but I think quickly discarded the possibility of having a notification system based on a distortion, because this would require, in essence, concluding the assessment before you can notify, which is not an evident thing. In particular, in a situation for this new instrument where there is no expertise or experience in actually implementing the instrument. So yes, financial contribution is a broad notion. In particular, in the certain contexts, it might be an even broader notion for involving many companies and undertakings. However, this is an objective benchmark which we felt was necessary to use for an ex-ante notification system. Maybe to conclude on this point, however, this notion is combined also with relatively high thresholds. You don't need to notify all the foreign financial contributions for everything, only for concentrations where, first of all, the foreign financial contributions amount to at least 50 million euros over 3 years, and in particular, where the target or at least one of the merging parties has a turnover in the EU in excess of 500 million, which is not a low threshold. It's much higher than the European merger regulation, for instance. And similarly for public procurement, you also have a relatively high threshold. I think you will see from our impact assessment, if you have a look, that we estimate, in particular for the concentrations, that this would result in approximately about 30 notifications per year. So again, relatively moderate burden. Thank
you very much. Alec, I'm wondering if I could bring you in at this point, and if you could run us quickly through the potential impact on foreign operators of the proposal as it currently stands and some practical implications of it.
Anna, glad to do that. And good morning to so many friends who I see in the list. Aoife, we even see you in person, but you may like to turn your camera and microphone off because we hear you clicking on your keyboard. Pavlos, you have control of your camera if you want to turn it off. I don't think we can do it centrally. The launch of the webinar referred to the particular impact on the United Kingdom, and that's an aspect that I'd like to bring a little bit to the fore in what I present here. The United Kingdom, the former member state, which is therefore targeted potentially like any other third country by this foreign subsidies regulation. Of course, we have the Trade and Cooperation Agreement, which itself has provisions on state aid and indeed dispute settlement mechanisms specific to state aid. And the United Kingdom is soon in pursuit of that to introduce a domestic rule. What's it called, Siobhan? It's the UK Subsidy Control Bill, or something of the...
Exactly, yep.
Which gives us a rich fact pattern here, recognizing that Alexandre's new proposal, or the Commission's new proposal, targets distortion of the internal market. The same subsidy given in the United Kingdom may also be subject to control in the new UK domestic system, and indeed subject to examination or indeed possibly recriminations under the disputes settlement mechanisms of the Trade and Cooperation Agreement. And I've conjured up, we'll show a little bit later, a case study which shows just how intricate life may become in that way. One single fact pattern can give rise to many triggers. And indeed, we know, don't we, Pavlos, we lost you for a while, but now we see you again. We've all of us in transactional practice experienced the sudden surge of foreign direct investment notifications. Those of us old enough to remember the start of the merger regulation are having a sense of deja vu, where suddenly you have multiple notifications. It's just that now it's multiple. It's a fact of life, but we need to learn to navigate it. One question that I throw out to you, Alexandre, which maybe you can mull and come back to later, is how the European Commission itself is going to operate when it has one transaction under review in 3 different notification procedures, which is to say merger regulation, foreign direct investment coordination, and this new subsidy regulation, to which of course you'll say to me there are separate procedures, and which I'll say in response, well, they're all decisions taken up on behalf of the college, and how are you going to get coherent? But just leaving that thought with you for a moment. I think it's a fascinating proposal overall, and it does fit exactly as you described, Alexandra, within the broader framework of international law. WTO subsidy control, not terribly effective. We're protecting things that we could have protected before and we hadn't. Maybe it's the end of the age of innocence brought on by China's, what's it called? Is it the BRI, the Bridge and Rail Initiative? Sorry, I don't have that acronym correctly. It may well be that we can't, from Europe, and I say we, that's we with my Belgian passport that I have nowadays, can't simply inject this new system of control into the world with no with no repercussions. We're doing what we're entitled to do, but it's going to make life rather more interesting and challenging. You say, Alexandra, that there have not been many adverse reactions. You're following it more closely than me, and I'm sure you're right as to the generality, but it was reported, not least by some of those who are in the call here, that there were, if not hostile, at least adverse reactions from the China Chamber of Commerce in Europe, and indeed the American Chamber of Commerce in Europe. And I noticed just a week later that China is proposing or considering a law allowing it to react against foreign sanctions and long-arm jurisdiction. Not clear whether this would be a sanction in that kind. It's certainly a long-arm jurisdiction if it's looking at money which is paid from Beijing to Shanghai. So life just got more interesting, which of course is a good thing. I'll leave it there, Anna.
Thank you, Alec. Alexandre, I don't know if you want to react straight away, but maybe I can bring Gavin Bushell with this question. Gavin, would you like to ask your question in person?
Yes, hello. I'm happy to do so. Thanks very much for the opportunity, and thanks for this event, which I think is a very timely discussion given the deadline for the feedback. I'm particularly interested in the section that deals with concentrations because of, as Alec rightly points out, it does create an additional layer of red tape and burden for non-EU entities doing business in Europe. I'm particularly fascinated by the fact that there doesn't seem to be a distinction made in the proposal or in the thinking between different types of inward investment. And you can envisage a number of different scenarios. You might have sort of a sovereign wealth fund, from a number of different countries, an important source of capital for businesses in Europe, or you might even have a state-owned enterprise, and Alec has mentioned, I think, one of them. Doing acquisitions in Europe, and they could be purely, investment acquisitions or portfolio acquisitions, which may not even raise any competition law issues whatsoever. And yet they're going to be subject to this additional, filing requirement. And as I understand it, there's this sort of the way that Article 23 works is that you sort of have to notify. There's a 25-day period, and then the Commission may open the in-depth investigation, and then at the end of the 90-day investigation, you come out with conditions or a no issue statement or a prohibition. And that seems to suggest that actually these types of important investments at no cost to any UK taxpayer are going to be subject to this additional administrative burden, even if they don't raise any competition law issues. and stand still for potentially up to 115 days. And I kind of wonder, why is it that the way that it's structured doesn't mirror more closely the framework of the merger regulation? It does in part, but it doesn't so closely, particularly in terms of timing. And doesn't that increase the sort of the burden and obviously increases the sort of renders less attractive Europe as a place for non-EU SWFs and SOEs to invest in Europe? And then just an additional point was about this Article 19.5 point, is that there seems to be some legal uncertainty being created by this residual pull-in power, which sort of says, well, if you don't like something, you could still pull it in. And is it not better to have a sort of bright line test where people clearly know when they're doing business in Europe where the parameters are in terms of what they need to do in terms of notifications?
Many thanks, Gavin. That's a lot of questions. I don't know, Alexandre, if you want to react, and maybe Siobhan, you would like to comment on some of the points as well. We were talking about quite a lot of, impact and differences in procedures and how the regulation might work in practice. And I'm wondering if you have any observations from your end.
Yeah, maybe I think if Siobhan wants to react, maybe that's indeed, and then I can respond later.
Yeah, I mean, I think generally speaking, looking at it from a practitioner's perspective and dealing with clients who are already subject to the merger regime, having another filing requirement added on that would potentially go at a different pace with a different case team, because the Commission has confirmed that there'll be 145 new colleagues that will be dedicated to this by enforcing it from 2025. That generally speaking, being able to counsel your clients to make sure that everything is covered, it can be a lengthy process. Are they all speaking to each other? Is it going to be overly administratively burdensome to do all of these, filings, including FDI as well? I mean, I think generally on the wider landscape, the feedback that we're kind of seeing is that it is burdensome. There's concerns, and just how it's all really going to work in practice. Just coming back to an earlier point that Alec had mentioned as well, I think generally speaking, these third countries are reacting. I kind of, in the impact assessment, it's clear they're going to keep on using subsidies, and post-COVID, generally speaking, it's understandable that the Commission's wanting to be somewhat protectionist about the sort of additional use of subsidies. There's going to be more acquisitions and increased public procurement. However, I think that the third countries do see this as a protectionist move. It essentially is extending our state aid regime to external jurisdictions, and there are a number of concerns linked with that. Thanks.
Many thanks, Siobhan. I think that I heard a lot already about the concern about how the new system would work, especially with multiple notifications and comments about different procedures followed even in the same institutions are obviously raising concern. One of the reasons I asked about the international reaction is exactly the long arm. It's exactly the extraterritorial application and how it will be viewed elsewhere, and what kind of reaction it will attract from international operators. Alexandre, I'm wondering if you would like to react at this point as well to the points raised by Gavin and then by Siobhan and Alec.
I'll try to react. I don't know if I'll be able to address every comment because there were quite a few, but maybe I have to start by saying that we really don't see this as a protectionist measure. And I think in a way, maybe the reason is that, and maybe a difference with state aid is also who you apply this to. We will apply this to undertakings, not to states. Third countries can do what they want in terms of subsidies, but if those actions are going to distort the internal market, well, in a way we have to do something. This is what we do under antitrust generally. And we don't see a good reason to leave a hole for this for foreign subsidies that distort the internal market. So really, at least from our perspective, this is really about really leveling the playing field. And again, third countries can continue to do what they want at home with their own subsidies. On the several regimes and administrative burden, I think this will be an additional instrument. That is clear. I think what is clear also is that already today there are quite a few instruments, and businesses and administrations navigate those as they can. I think our intention with the proposal is definitely to limit the incremental burden on businesses in particular as much as possible. And so I think there might be ways in practice to do this in implementing the instrument if adopted. But I think these things will be decided later. I'm thinking in particular ways of streamlining notification and the information requirements, etc. In terms of being consistent within the Commission, indeed, I think we have an interest to do so, and we will have to find ways to do that. This being said, I would also emphasize again that the thresholds are quite high, and in particular, going to Gavin's point about the types of investments and sovereign wealth funds. I think in terms of types of investments, this instrument does not exist yet. There is not a lot of transparency on foreign subsidies, and so it wasn't really possible, in our view, to circumscribe the instrument to certain sectors or types of investments and exclude others. However, it's not excluded, and I think there is a possibility indicated in the proposal to perhaps reflect, once we have experience in the future, if that would make sense on the basis of the facts that we would then have. However, again, going to the thresholds, it is a very targeted instrument, and very few cases would be captured. These cases would also, in all likelihood, be captured at least by the EU merger regulation, and so it's not that we would create an administrative hurdle, in particular because you say they're not fully aligned, but I mean, in principle, the timing for the concentration module is aligned with the merger control timeline. And so, again, this is our objective, to try to have a streamlined, effective process, and limiting the incremental burden as much as possible. And then also maybe again reminding that there are already a lot of regimes, and even alignment within merger control across jurisdictions internationally is not necessarily a given, and is not so easy. So again, it would be a new instrument. It would bring some more work. We would try to minimize this, and the extent to which it would be really a hurdle is unclear. And in this regard, I think it has been, at least I think this is in our impact assessment, but I think it is known otherwise, that there has been some assessment of the impact of the FDI regulation on FDI in Europe, and I think the conclusions there is that there might have been a slight decrease of FDI immediately thereafter, but that this has then recovered more recently, and so we would expect probably the same trend. Again, because the ex-ante aspects are really limited, so we don't see that there would be a huge impact on FDI generally.
Alexandre, thank you very much. I'm wondering if we can have a bit more of a discussion about those different procedures and how they actually work in practice so far. And Alec, I'm wondering if you can give us a little bit of an overview how the current obligations apply in practice.
You're thinking, Anna, of the different procedures at the European Commission?
Yes, exactly. So FDI filing obligations, merger regulations, because I think it would be good to have an overview actually what kind of procedures are followed, whether deadlines are roughly the same, whether the thresholds are the same, etc.
Gosh, I defer to Siobhan, who may have a more specific mapping of turnover thresholds. What fascinates me, as seen from the outside, is the way that different branches of the Commission will interact on all of this. At the moment, we have two regimes in existence. The foreign subsidies is for the future. The merger regulation exists, and then there are FDI. The FDI regulation is a consultation mechanism. It's not a notification to the European Commission directly, but member states which have FDI regimes, and there are an increasing number of them, are meant to inform the Commission, and the Commission has a role, a ringmaster role, trying to bring some coordination, and indeed is allowed to express an opinion which is meant to be given particular consideration, even if it's not binding, if the project affects a matter of significant European interest. I'm not aware, at least I haven't myself been involved in a case which has been both under the merger regulation and under an FDI coordination through DG Trade. Maybe there have been, and any of our band of celebrated practitioners in the call have some experience and would like to come online and tell us about it. The time must surely come where there will be a case which is controversial under national FDI regime, and the European Commission has a view, and it's also under the merger regulation. I'm, again getting out my my shtick, which says I've been at this for a long time. I remember when the merger regulation was brand new, the merger task force shut themselves away on a separate floor of the building. It was then on Kortenberg, and had separate security passes, and no one outside of the merger task force could get into any merger materials, even though they were DG Comp. And I think that's actually still the same way, and it's good and proper that those things are dealt with separately. But then at some stage, the mergers network, as we call it nowadays, has to branch out. Consultation with the legal service, papers to the cabinet in advance of the college meeting, indeed before that inter-service consultation. And all of this recognizes that while the mergers officials and the FDI officials have narrow responsibilities under the merger under their instrument, they are doing something on behalf of the Commission, and ultimately it will be a decision taken in the name of the college. Knowing Brussels as we do, there will be any number of public affairs consultants willing to lend a hand and try and tap into the decision-making network and have some influence, all of which is going to be exciting enough under FDI before we add in the foreign subsidies aspect in future. The Commission must surely look to act with coherence on a single set of facts, particularly if there are remedies going to be needed. And all of those three regimes can imply remedies. I watch with fascination, but I'm sure Alexandre has the simple solution how all this is going to work.
Before passing to Alexandre, thank you very much, Alec. I can see Siobhan nodding, so I'm wondering if you have any immediate reaction to what Alec was saying, and then I can see another question from Gavin.
Yeah, so I mean, generally speaking, I'm kind of, thinking as a sort of merger control practitioner, and just, the developing wider horizon of what we're looking at here. We're used to number crunching and going through all of, the thresholds. Is it EU? Does it trigger EU? Multi-G? And, we're all very used to doing that. And so kind of like pulling in kind of an analysis under the FDI, I think that many merger practitioners, just taking that into their practice automatically. So for the lawyer reviewing it, I mean, I think in terms of just adding another set of thresholds to check if things trigger or not, is going to just come straight into sort of like the merger control practitioners kind of toolbox of review for the client. It is just kind of then just, I suppose, getting the assurance that that the Commission will start, if it triggers all three, how it's going to be dealt with, how it's going to be streamlined, and just to kind of make sure that there are efficiencies where there can be, and it's not overly administratively burdensome for the clients involved that are having to deal with all of those different procedures at the same time.
Thank you, Siobhan. Alexandre, would you like to respond?
Yeah, I mean, just briefly, I think we're very well aware of this, and indeed, as I mentioned, our intention is really to have something streamlined, but this is really early days, and so I think these details will need to be fine-tuned in due course. Maybe, Alec, on your points, already today there are indeed already two instruments, although the FDI regulation is a bit of a different instrument than the EUMR. But what I can say is that also for this proposal, we have worked closely with other commission services, and particularly G-Trade, and so there is a sharing of expertise. This being said, it's true that while a specific set of facts may be reviewed under different legal instruments, these are different legal instruments with different legal standards and also which pursue different objectives. And I think to a certain extent, it makes sense that you have separate assessments under these different instruments. Where you're absolutely right is that in particular where this may have a direct effect is in terms of aligning remedies, or maybe not aligning remedies, but having remedies under all three instruments. Of course, this will then have to be dealt with. But again, because the objectives are slightly different and the legal standards are a bit different, it's not a given that the remedies will be either the same or also directly incompatible under the different instruments. So I think it will really need to be a case-by-case assessment. Apologizing for this unhelpful response.
You're right, of course. When the individual cases come, and of course the pressures are on from different directions, not least from governments, we shall see. Always under the looming shadow of the court in Luxembourg, for which purpose decisions will need to be based on the evidence and objective. So I said before, life just got more interesting.
Thank you. I can see Gavin has another question, so I'm wondering, Gavin, would you like to come in and ask the question again?
Yeah, no, thanks. I'm sorry to be talking so much, but there's a lot of questions being raised by the proposal. What I've put in the chat is that Article 4.3 and Article 4 itself identifies those types of subsidies and operations which are most likely to distort the internal market. And that kind of concerned me because certainly in 4.3, it seems to appear to create a structural presumption that a foreign subsidized acquisition meeting the thresholds that's notifiable is inherently bad. And that contrasts to the situation under the EUMR, where the court has confirmed that the tool itself is neutral. It's up to the European Commission to do the work and to work out whether it's good for competition or bad, and then it has to prove it to the relevant standard. So by inserting 4.3, you're effectively saying, well, because it is subsidized, it's inherently a bad thing. And that kind of makes me get extremely worried, because if you go to balancing, and I'm worried about balancing anyway, because if it were to mirror in any way, for example, the balancing that's done under the EUMR, where I think there's an unfair framework for the assessment of efficiencies, it seems to be a very lopsided system in favor of intervention. And so that sort of essentially worries me that it would give, I think, not a very fair, it's about the equality of arms, not a very fair opportunity for a sovereign wealth fund or an SOE or another subsidized company to come in and try to argue it, and ultimately they would end up giving up commitments. So I'd agree with Alec that I think there's a lot of fertile ground here for future challenges to the court, particularly on the mechanism relating to concentration, because you've got to have this, you've got to have the subsidy in the first place, you've got to have this improvement, whatever that means. Then there's got to be a causal link to the concentration. And so all of those separate elements, some of which are not very elaborated, I think are going to be tested before the court to demonstrate. And things having a presumption, a structural presumption of harm, I think skews that debate in terms of having a fair equality of arms.
Many thanks, Gavin. I don't know, Alexandre, if you want to react, or Siobhan, would you like to comment further from your experience?
maybe if I can just say, and I see also that my colleague Simona Hitzek-Seidel has joined the webinar. I don't know if she wants to also maybe complete my intervention, but Gavin, to be frank, I don't see that we have a presumption of harm here. Frankly, Article 4 is about categories which are most likely. In our view, this is a bit of a differentiated burden of proof for the Commission, but it is not a presumption of harm as such, in particular because, well, these categories, we would still need to show that they distort the internal market, a subsidy falling in these categories. And that is not, I don't think that's a given on the face of just, you received an unlimited guarantee and it stops there. I think you need to show a bit more than that in any event. This being said, I do see a difference with the EUMR, and on that point, I would maybe revert to my initial remark, which is also that the main benchmark has been state aid, right? And I think there are a lot of parallels also with antitrust and merger control, in particular because we're targeting undertakings, but still the main benchmark remains state aid. And in that regard, the EUMR is a neutral text. I mean, legally, the instrument is neutral. There is no presumption one way or the other. As you can see, the proposal here is a bit different. There is no, again, I don't think there's a presumption in one way, but there is a differentiated, in a way, burden of proof and approach. And I think if we build that in the legal instrument itself, and if that is adopted then by the legislator, I think that is an objective difference just in the legislation. So I think, yeah, it's not just about then implementation. But indeed, I think the court, I mean, hopefully the instrument will be adopted, and I think inevitably then the court will have to pass judgment upon it. And I think that's a very positive and natural thing. And I don't know if my colleague Simona wanted to complete.
Thanks, Alexandre, but there's nothing to add from my side. Hello, everyone, by the way.
No. Thank you.
And I just puzzling Gavin, and Gavin, good morning. Gavin's references to sovereign wealth funds and state-owned enterprises. Article 4.3 that Gavin calls out for everyone's benefit is the Article 4 identifies the types of foreign subsidies which may distort the internal market, and 4.3 is a subsidy directly facilitating a concentration. There's no reference as such to sovereign wealth funds or state-owned enterprises. Your assumption, Gavin, implicitly, if I follow you, is that by the very nature of a state-owned enterprise or a sovereign wealth fund, they are actually nothing more than a bundle of subsidies. That is what they are. It's state money.
Yeah.
I'm not sure that that's right. At least I'd be interested to call it out and see what Alexandre says, but just leading into that.
Well, I think the point is that sovereign wealth funds and SOEs are not delineated in the sort of the proposal itself. So it's a financial contribution includes capital injections. So on a literal interpretation, if you have an entity that's been funded by the government for whatever purpose, whether it be for investment or otherwise, it is arguably caught, and therefore SWFs and SOEs would be caught by this. Yes,
Gavin, that thank you articulates it much better than I had. Under the merger regulation, we have the important recital which says that there's no discrimination between state-owned businesses and private sector businesses, and that's been applied, for example, in relation to state-owned enterprises in China. The case involving EDF, I think it was Hinkley Point, the nuclear reactor in the United Kingdom, to identify that the state-owned enterprise which was participating in that joint venture was part of a larger group of state-owned enterprises because they were under the immediate supervision of a so-called SASAC, S-A-S-A-C. And again, I don't recall what the acronym stands for, but a state supervisory body for a branch of the Chinese economy. the view was not taken in that case that all of China is one business, China Inc., although frankly there's a case to be argued for that, because all of the SASACs respond to the dictates of higher authority in China. But under the merger regulation, at least, there is no there is a clear rule which says you don't pool everything and treat them differently. You only go up to the level of control. I don't know the foreign subsidy proposal well enough to have noted whether there's anything equivalent there, but that's one question. And then more generally, Alexandre, how do you intend to look at companies which are by their nature constituted by capital contributions of public money?
Alexandre, before I go to you, I'm wondering, Siobhan, if you would like to comment on some of the points that were raised.
No, I'm happy for Alexandre if you want to respond on that.
Of course, happy to do so. I think, I mean, the short answer is we will deal with them as any other undertaking. I think, Alec, you rightly point out a bit of, I mean, it is explicitly in a recital to the UMR, but it is also a broader general principle that, we don't discriminate also between them. It's the competitive neutrality principle. We don't discriminate between public and, and that's the type of ownership. So on the specific point of capital contribution, I think there are several things to keep in mind. In principle, indeed, an entity with a significant public capital contribution, well, that is public money, and it needs to be assessed in the framework of the proposal. This being said, if we mention specifically government concentrations, that's not the only element to take into account. I mean, you need to be acquiring a target with a turnover in excess of 500 million euros, which in my experience, even for sovereign wealth funds, is not so common. And so you probably wouldn't have so many cases. And then you also need to find that there's a distortion of the internal market of that operation. So I think it's only one part of a very complex and lengthy assessment. And so, but indeed, in principle, a public money in form of capital contribution would be a foreign financial contribution, and we would need to be assessed under the instrument. Maybe just to flag in the last 3 years, right, to be again to fall in the notification module. So again, capital contribution earlier than that would not fall in scope, not the ex ante notification, Exoficio possibly.
Thank you very much, Alexandre. Alec, I'm wondering if it's if you would like to elaborate a bit further on the practical implications for operators under the different notification regime. And I know you have prepared a presentation on this.
Yeah. Let me try and call up my slides, which why don't they show easily? No, it's not that one. I thought I had lined these up before. Aha. How about this one? Are you seeing that?
Yes.
I have here a case study in which we hypothesize that there is a Chinese parent, and it's a parent of a UK company it's previously acquired, and the UK company is going to make an acquisition in France. The company being acquired makes drones. Drones might be the innocent stuff that Amazon uses to drop parcels in obscure locations, but of course drones can be military, so sensitive technology. And there are 3 different sets of public money changing hand here. First of all is over on the right-hand side, the money that the Chinese parent enjoys from the Chinese government. It might be soft loans, for example. And then let us say that there is a specific sum of money which goes from the parent to the UK subsidiary to facilitate the acquisition. But also Boris Johnson, in his wisdom, levelling up the economy, wants to help this company with some regional funds, say UK money. So 3 pots of money to assist in this acquisition. And you've seen that there are subsidiaries of the target group in a variety of companies, not chosen entirely at random, I should say, as we'll see. Narrowly within the subject matter of this proposal, the TCA, the future foreign subsidies regulation shows the European Union outlined in red. The UK is there. The UK has got domestic subsidy control, or will in the future. And then there's the relationship between the UK and the European Union under the Trade and Cooperation Agreement. So all of that, without going into any further complexities, which I will in the following slides, shows you 3 separate branches of possible legal interest. Then if we look at the foreign direct investment aspects of this, there are FDI regimes in certain member states of the European Union, shown blocked in yellow, but the whole of the European Union is involved in FDI because of the European Commission's role in coordinating national reviews. The United Kingdom here is yellow because we have the new National Security and Investment Bill, which is indeed not a bill, it's an act, not yet fully in force. And then the United States has CFIUS, Australia, and so on. So a whole wealth of multi-jurisdictional practice for the FDI. Merger control in this case, assuming always thresholds are met, in the European Union, in the United Kingdom, South America, US, Australia. And then bringing that all together, I grant you the graphic at this point is difficult to read, but if you look at the box over on the left-hand side, that is a rich set of multi-jurisdictional filings for you, Siobhan, to coordinate. And indeed all of us. How do I stop sharing?
Thank you very much, Alec. I think that really illustrates the challenges for international enterprise as well, and actually showing very different regimes under which you have to file, and you know, dealing with quite a big regulatory patchwork, and the differences that you've shown between the countries to show that in some cases it may be FDI filing, in some cases it might be merger control. I'd like to pick up on the issue of the TCA, and Siobhan, I'm wondering if I can bring you in here just to give us a quick overview about of the TCA provisions and subsidies, and actually perhaps maybe a quick overview of subsidies in trade agreements, if I may, because there are plenty of trade agreements where of the EU and not only EU, where you actually have provisions on subsidies. Some of them relate to WTO, but some are a bit more expanded. I'm wondering if you can give us a quick overview, and then I would like to move on towards the UK, if that's okay.
Yes, absolutely. So you have your kind of start off with your bilateral FTAs, and they generally have quite large differences between them on subsidies, and it will kind of like aim to look at transparency, consultation, and potential prohibition of certain subsidies. Generally, sort of with the EU, sort of the FTAs, the subsidy control systems have been largely inspired by state aid, but none of them go as far, obviously, as the TCA. What this does allow is those countries effectively can better identify what would be a distortive subsidy. So then the Commission has a choice. If there is an issue, they can open a case under the FTA, or they can take a separate legal action, particularly if the partner in question doesn't take the corrective action or stalls the procedure, and clearly that would be where this foreign subsidy regime comes in. Looking to the TCA in particular, just by kind of like very general overviews, all subsidies fulfilling the conditions of Chapter 3 of the TCA are covered. But kind of like if you have a remedial measure it's taking where the subsidy caused significant negative effect on trade and investment, the TCA itself may fail to remove the distortive impact of the subsidy on the EU internal market, and that is again where this foreign subsidy proposal, would kick in. Looking to the UK subsidy regime, I mean, what we've got at the moment is, the TCA. So it's repealed our state aid status, and there was no transitional regime or guidance in the interim. So as of the 1st of January, basically, we have 6 core principles of subsidy control that are covered under Chapter 3 of the TCA. The intention was that this would be permissive and flexible and absolutely not restrictive. And so generally speaking, in the UK, the subsidy may be granted if it complies with these very high-level principles, and it's not a prohibited export subsidy. There's some limited de minimis thresholds, but there's no block exemptions, there's no regulations, there's no decisions in place at the moment. You've got 6 principles, and generally speaking, without that framework that we had from state aid, it's caused a lot of uncertainty in terms of its application within the UK. I think while the intention was there to make it a much more open system, the problem was that as things kind of accelerated and the TCA got cleared at the end of last year, essentially, that there was no simultaneous guidance framework that came along. I mean, we've got some very high-level technical guidance on the UK's international subsidy control commitments, but in practice what's happened, I mean, we're 6 months in now, is that in order to gain comfort, the state aid rules from Europe are still effectively being applied, because it's seen kind of like from a practice perspective that, they will definitely be TCA compliant, and everyone understands what that sort of like, decades of block exemptions and decisions. So therefore, in essence, the practical effect of it is that the greater freedom that the UK has under the TCA and the subsidy regime is restricted. But BEES, put out a consultation. It was between February and March. It was a pretty hefty consultation, kind of like 43 questions. It looked as to whether we want a pre-notification regime in the UK. It doesn't look like the government's particularly supporting that. But, these are the questions. It was like, where in the spectrum is the UK going to sit in terms of its subsidy? What are the powers that a regulator is going to have? And so the subsidy bill has, featured in the Queen's speech, but it's very clear for operators. I think that we need guidance, which will be forthcoming, but at the moment, it's not clear where we're going to actually land from the UK perspective.
Thank you, Siobhan. This is a very good overview, and actually suggests that there is much needed clarity, at least in the UK. Alec, I'd like to come back to you because you mentioned the impact on the UK at the very beginning of your presentation, and I'm wondering if you have any comments already to what Siobhan was saying at this point.
Well, no, I mean, I can talk and fill time, but I think Siobhan has nailed it so far as there is anything that we know at this stage. I'm rather keen on myself seeing the wealth of expertise of those who are dialed in to the webinar to have perspectives. If indeed anyone wants to unmute, even on camera, and tell us we're wrong.
So at this point, maybe I'll bring you, Alexandre, if you would like to react to anything that was said. And then I'm gonna go to the audience, and I can see that there are questions in the chat.
Then I'm happy to quickly react. I think, as we've mentioned several times, I think in principle, FTAs and the new proposal would apply in parallel, because there are different legal tools which apply pursue different objectives and apply to somewhat different situations. In particular, the proposal is about undertakings receiving foreign subsidies and how this might distort the internal market. It's a different setup from the TCA, which is about the subsidies as such on a sort of state-to-state level and distortion of trade rather than the internal market as such. So I would leave it at that, and I suggest we go to specific questions from the participants, which I think might be interesting.
I can see there is a question from Maurice Schoenberg on interaction with the TCA. If a UK subsidy is consistent with the subsidy control principles under Article 366 of the TCA, would it still be liable to be challenged under the proposed regulation? I leave it to the panel to choose who might actually wants to respond on it to this.
Well, then maybe I stay silent. No, I'm happy to have a first go. I think it's a very good question, but as I just said, in principle, these are separate legal instruments. So I think the assessment under the proposal regarding foreign subsidies would be a bit of a different one, and we would really assess the distortion. So in a way, again, a bit of a different assessment to be seen.
It's clear that certainly there's nothing automatic. Status and satisfactory status compliance under the one regime has no impact as such under the other regime. On the other hand, when you get to the stage of substantive analysis and discretion on what to do, there must likely be a strong tendency not to make trouble. Of course, when you get closer to a specific set of facts, it may not be so obvious.
Yeah, I think generally there may be situations in which ultimately the TCA fails to remove the distortive impact of the subsidy, and I think in such a case that it would be possible to revert to this foreign subsidy regime. But yeah, hopefully there would be some clarity on how the two would be expected to interact for clarity for market players going forward.
I can see a question from, hand raised from Laurent. Laurent, do you want to come in?
Sure. Thank you very much. Good afternoon. First of all, maybe just a comment on the point raised earlier about state-owned enterprises and sovereign wealth funds. I mean, you do have a condition, not just that there's money coming from the state, but you also have the condition that it provides a benefit. And that's not automatic for actions even of a government in relation to a sovereign wealth fund or a state-owned enterprise. There is one relevant provision in that regard. Article 14 of the proposal, which is about non-cooperation, does say where an undertaking concerned, including a public undertaking, which is directly or indirectly controlled by the state, fails to provide the necessary information to determine whether a financial contribution confers a benefit to it, that undertaking may be deemed to have received such a benefit. And I think that's a very important point, especially because in my experience in the international trade context dealing with the anti-subsidy regulation, it is very frequent that the third country does not provide full cooperation with regard to the subsidies it's providing. The other point I wanted to raise, though, was on the interplay, in particular with the WTO ASCM. You have this Article 40, paragraph 7, which says no action shall be taken under this regulation, which would amount to a specific action against a subsidy within the meaning of Article 32.1 of the WTO agreement. And I'm really wondering what people think is going to happen with regard to sectors that produce goods, because the ASCM does apply to trading goods. And under the ASCM, you do have this traditional measure of anti-subsidy duties, but you also have the possibility of WTO dispute settlement. And for goods, for example, in sectors where there are no imports, so they cannot benefit from anti-subsidy measures, you would say, well, they can do WTO dispute settlement. And indeed, we have the example of the shipbuilding industry, where the EU brought a case against Korea in the early 2000s. Now, the way I read this, you interpret this basically as any sector which produces goods has no recourse to this new tool. And I'm a bit curious to hear how Mr. Bertuzzi would characterize this, whether I'm reading it as too strict. And you could take this a bit further. You could say, well, what about sectors which not only produce goods, but also provide services at the same time? Is there going to be some kind of apportionment? Are we going to say, well, certain subsidies or certain distortions are covered and others not? I think this is a very basic issue that needs to be addressed. Thank you.
Thank you very much. Alexandre, Siobhan, Alec?
I'm happy to start. I think you're right. I think it's I believe it's Article 47, paragraph 7 of the proposal. Indeed, goods in essence are carved out of this new instrument. Correct, precisely because they're covered by the ASCM. And as I mentioned, we were very attentive to make our proposal compatible with our international obligations. When it comes to combined goods and services, this is not my field of expertise, so I won't say much. I understand that in the trade defense practice, there is some experience and practice in terms of how to allocate, let's say, respective value of services and goods when there's sort of a combined offering, or to determine whether given conduct relates to goods or to services. I imagine that a similar type of assessment would need to be followed.
Okay.
Thank you.
I don't have wisdom to offer in relation to the question of goods. I'd like to look into that more. And Laurent, good morning. Thanks for the tip. The procedural point that you draw attention to, we should very likely have given more prominence to early on, the ability to proceed on the facts that you have in the absence of cooperation. That's certainly been important in anti-subsidy and indeed in dumping cases, all of which adds to the spice of this situation. There will be incentives, no doubt, to cooperate to some extent, all of which left me musing on, Alexandre, your distinction between protectionism and levelling up the playing field. I guess it choose its question whether you want to look at the bottle as half full or half empty. This does level the playing field. It's maybe the whole regulation signals the end of the age of innocence, just leaving the market open and not wondering about anything else. And we level up the playing field by being more protectionist. You can call it leveling the playing field or protectionism, but in any event, we do now plan to operate more defences.
Just to come back on a couple of those points as well, I think with the WTO SCM I think in the impact assessment that's looked at in some detail, and particularly how this is meant to be plugging a gap that it doesn't cover. So it recognises the limitations of the SCM. And therefore tries to fill in what is left. And I think to some extent it's the same with the European TDIs. I mean, it is goods that they look at, not services, and particularly when we're looking here, it's about its investment and other financial flows for undertakings operating in the EU. From the procedural perspective, I think that's a fascinating point, and I think that it is in part also in relation to the cooperation of third countries, because the Commission may carry out on raids in the EU, but when we're looking at the third country, it has to have the agreement of that third country, you know, to go and do an investigation for the undertaking based there. So it has to have the undertaking's consent and the third country's consent. But where there is no such cooperation, it may also be able to come to a decision on the information that's available to it. And I think that that may well act as an incentive itself for third countries to perhaps cooperate. But indeed, from the trade defence instruments, I know very well that they can be rather uncooperative. Thanks.
Thank you very much. I'm wondering, I'm mindful of the time. We have like 2 minutes left, but maybe there are any other questions from the audience. You can please raise your hand. No. Well, then perhaps I can invite you all, Alexandre, Alec, and Siobhan, if you have any final comments, you know, on what we were discussing today, because I heard quite a lot of questions about how to interpret the new proposal and how it will work with other instruments and the interplay, indeed, with the WTO, and what kind of procedural concerns there are, especially when the investigation is to be carried out outside of the EU, the uncertainty in the UK, and the fact how to interpret the subsidies and how to treat slightly different definitions. I mean, we had a discussion about Article 4, but you know. And I'm just wondering if you have any final points to make at this stage.
I didn't acknowledge, but it is important that Alexandre stressing throughout the way the thresholds have been raised so that it will be a limited number of cases. I do think that's important. What we've experienced with merger control and FDI suddenly is that all manner of things can get drawn in. FDI control is particularly alarming because it can affect very small percentage interests. Alexandre, it's no doubt outside of your daily and weekly field of interest, but FDI suddenly occupies the merger control fraternity a great deal in relation to transactions. The impact of the foreign subsidies will be more limited, which is not to say that it's going to be negligible. Quite on the contrary, when you get significant cases which raise these issues centrally, it will be a challenge.
Siobhan?
Yeah, just very quickly, I agree with that. I think, generally speaking, I mean, this has been in the pipeline for quite a while. The thresholds, you know, from the previous proposals, you know, they've gone up. There's obviously a gap to fill. That's clearly recognised, but because of things lacking in the other protectionist instruments, and so it will just be a case of, you know, building it into our regimes and, you know, ensuring kind of like as much compliance as possible. But it's a very interesting development. Thanks.
Thank you, Alexandre. Any final points?
I also completely agree, and I think hopefully this instrument will become a new legal instrument, and indeed it will have to be applied. I think what I can say is that the Commission will apply it as usual on the basis of the facts and the evidence that it has under the control of the court. I think that is, in my view, a very good setup.
Well, thank you very much for your points. Thank you very much for your presentations, the discussions, and the questions that you raised. Thank you very much to the audience for your participation. And if some of you would like to access this event again, we are going to upload it on our website, and we will send the link to all participants. Alec, Siobhan, and Alexandre, thank you so much for taking part in the discussion today. It was a really interesting discussion and raised many important points, and I think it was helpful to you and to the audience as well. Thank you very much.
Thank
Bye.
you very much.
Thank you.
Goodbye.